Slam dunk, are you ready to meet me? I'm here and I'm riding the fast lane. Don't let me down, I'm on fire. Does anyone else feel like a liar? It's all in your head and right. You just never use it.
All present. Session 1 of the Walker-Moot Supreme Court in the Lenzner-Slatt Supreme Moot Court is now in session. We would like to acknowledge that we are speaking to you today from the traditional unceded territory of the Algonquin Anishinaabe people. We speak today while paying respect to the traditional knowledge keepers and the Algonquin peoples and all Indigenous peoples in the region of Ottawa who call the national capital their home. If you are not located in Ottawa today and do not know about the traditional territory on which you're located, we encourage you to navigate to websites like nativeland.ca to find out. And we also encourage that you learn more about decolonization by consulting the TRC calls to action as a starting point. It is with great honor and privilege that I present Justice Dr. Pierre Coury, founding member of the FLCCC Alliance and co-author of the Math Plus and iMask Plus prophylaxis and treatment protocols for COVID-19. Dr. Coury has appeared before Congress on several occasions and has led ICUs in multiple COVID-19 hospitals throughout the pandemic. He has co-authored 5 influential papers on COVID-19, with the most impactful being a paper that was first to support the diagnosis of early COVID-19 respiratory disease as an organizing pneumonia, thus explaining the critical response of the disease to corticosteroids. We are also joined by Justice Dr. Ira Bernstein. Dr. Bernstein is also the co-founder of the Canadian COVID Care Alliance. We are also joined by Justice Dr. Joseph Varon, Chief of Critical Care Services of United Memorial Medical Center and United General Hospital, member of the FLCCC Alliance. Dr. Varon's extensive credentials include a residency in internal medicine at Stanford University, and he is the recipient of multiple awards, the latest of which is a proclamation of Dr. Joseph Varon Day in Houston for his essential and outstanding work during COVID-19. We are also joined by Justice Dr. Leon Rivlin, Medical Director and Chief of Emergency Medicine at Humber River Hospital, specializing in chronic pain and emergency medicine. We are also joined by Dr. John Granton, Head of Respirology at University Health Network, Mount Sinai Hospital, and Women's College Hospital. Dr. Granton is a consultant in respirology and critical care at the Toronto General Hospital and professor of medicine at the University of Toronto. He established and remains the director of the pulmonary hypertension program at the University Health Network. His hospital administrative activities include chair of the Pharmacy and Therapeutics Committee and the president of the Medical Staff Association. His research interests are in pulmonary hypertension and critical illness. He has published in several prominent journals, including the GAMA, the NEJM, American Journal of Respiratory and Critical Care Medicine, and the American Journal of Respiratory and Cell Biology. We are also joined by Justice Dr. Jamie Spiegelman, President of the Medical Staff Association at Humber River Hospital and critical care specialist. We are also joined by Justice Tori Hibbett, Chair of the Canadian Bar Association's Health Law Section and member of Miller Thompson. We are also joined by Justice Karen Hamway, partner at Dowling WLG. We are also joined by Justice Donald Dow, partner at Gowling WLG and the head of Medical Defense National Practice Group. Finally, we are joined by Justice Thomas Sutton, partner at McCarthy Tétrault, all presiding. On October 19th, 2021, after battling COVID-19 for 18 days, Kyla Stark died in the ICU ward of Fallview Health, 13 hours after her transfer from West Valley Memorial Hospital. Mrs. Stark's medical records revealed she was in perfect health. She had no previous existing medical conditions, nor any prior family medical history that would indicate otherwise. She was double vaccinated as of August 1st, 2021. On October 1st, 2021, Mrs. Stark tested positive for COVID-19 and contacted her longtime physician, Dr. Sophia Strange, and obtained a prescription for ivermectin. Though all pharmacies in her area were out of stock, Mrs. Stark's condition was stable. On October 5th, Mrs. Stark was notified that her local pharmacy had just stocked ivermectin and her prescription could be filled, but that same day, Mrs. Stark had developed severe shortness of breath and mild hypoxia and was admitted to the defendant's hospital, where she was placed under the care of Dr. Myrtle Papadopoulos, a third-year medical resident. Mrs. Stark immediately requested that Dr. Papadopoulos administer the ivermectin her family physician had prescribed, a course of treatment which he chose to reject. On October 6th, Mrs. Stark was moved into the ICU and placed on a nasal cannula during the day and a BiPAP at night. Mrs. Stark was treated with the hospital's COVID-19 protocol, which consisted of dexamethasone and pure oxygen. On October 7th, ivermectin was administered after Mrs. Stark's family pleaded with Dr. Papadopoulos. Within 11 hours, Mrs. Stark's condition had improved greatly. However, her supervising physician on staff, Dr. Lutzier, chose to withhold any further administration after being informed of Dr. Papadopoulos' use of ivermectin. On the evening of October 8th, Mrs. Stark's condition worsened and she was sedated, intubated, and put on a ventilator. Almost immediately thereafter, Dr. Lutzier was contacted by Dr. Strange, who strongly requested ivermectin continued to be administered, in addition to the Math Plus protocol. In response, Dr. Lutzier asked Dr. Strange to forward him the relevant literature for which she was relying on so that he could make an informed and rational, educated decision, which was provided immediately after. Dr. Lutzier determined his time would be better spent attending to his patients rather than reading as what he referred to as propaganda. On October 10th, the ICU nurse, Dolores Patel, was convinced by Mrs. Stark's family to speak with Dr. Strange over the phone. Dr. Strange pleaded with Nurse Patel to administer the frontline COVID-19 Critical Care Alliance Math Plus protocol. Nurse Patel spoke with the attending physician, Dr. Andy Park, and convinced him to undertake Dr. Strange's request. Within 15 hours, Mrs. Stark's ventilator was turned down, and Dr. Park and hospital personnel began the process of trying to bring her out of the medically induced coma. On October 11th, Mrs. Stark's condition had improved, at this point having only to rely on a nasal cannula. On the morning of October 13th, Mrs. Stark's family was informed by Nurse Patel that the hospital had misplaced the ivermectin, but there was no need for concern as Mrs. Stark was making great progress. However, Dr. Lutzier once again assumed care of Mrs. Stark, and upon learning the patient's treatment course, chastised Nurse Patel and the medical staff for administering the Math Plus protocol. Dr. Lutzier then administered remdesivir to Mrs. Stark. Nurse Patel phoned Mrs. Stark's family and informed them that Dr. Lutzier had assumed care and denied any further administration of the Math Plus protocol. The family was unable to reach Dr. Park, who was volunteering in Sudbury as part of an initiative to help provide critical care to patients battling COVID-19 in rural communities. At 1:27 a.m., Mrs. Stark's oxygen level began to drop and she became unstable. Within 3 hours, Mrs. Stark was again placed on the ventilator. The family arrived at the hospital, but were denied access due to the hospital's COVID-19 protocols in place. Mr. Stark phoned Dr. Strange and pleaded with her to get involved. Dr. Strange placed several phone calls and emails to Dr. Lutze, but after 4 unsuccessful phone call attempts, decided to drive down to the defendant's hospital in an attempt to manage the situation in person. Upon her arrival, Dr. Strange was too denied access to Mrs. Stark and was unable to speak to Dr. Lutze. Within 6 hours, Mrs. Stark's chances of survival were down to 20%, and Dr. Lutze informed Mr. Stark that he had exhausted both his course of treatment and COVID-19 protocol in treating Mrs. Stark. Mr. Stark pleaded with Dr. Lutze to administer the Math Plus protocol and offered to sign a release, releasing Dr. Lutze and the hospital and any of its agents and parties acting on its behalf from any and all liability arising from administering the Math Plus protocol to his wife. However, Dr. Lutze refused to administer Math Plus protocol, and a verbal confrontation ensued outside between Mr. Stark and medical staff, and security removed him from the building. On October 19th, Dr. Lutze agreed to transfer Mrs. Stark to Fallview Health, where Dr. Strange was on staff and would therefore be able to assume care for her. However, less than 1 hour after arriving at Fallview Health, Mrs. Stark died. In this matter, the questions at issue are the following. Issue A on standard of care. What is the requisite standard of care for medical negligence in Canada as correctly applied to this case? Secondly, did Dr. Lutze breach that standard of care in A, failing to investigate the literature he was provided with, and B, denying Mrs. Stark treatment with Math Plus or ivermectin alone? Issue B on causation, did Dr. Lutze's conduct cause or contribute to the harm or injury Mrs. Stark sustained? And finally, issue C on vicarious liability, is the hospital vicariously liable for Dr. Lutze's actions? Justices of the panel, I present to you, speaking on behalf of the plaintiff, Mr. Stark, in today's matter before the court, Alexandra Robbins and Owen Guinn, and speaking on behalf of the defendant, Dr. Lutze and the West Valley Memorial Hospital, Nicole Davidson and Manit Kahlon. We are here today to determine the outcome on trial before the court on the matter between Mr. Stark, Dr. Lutze, and the West Valley Memorial Hospital. Both plaintiff and defendant's counsel will have 40 minutes each in total, so 15 to 20 minutes each counsel member, to present their arguments to this court, including answering questions from the bench. The plaintiff will present their argument first, followed by the defendants, and then a 3-minute rebuttal may follow by the plaintiff if they so choose. I will signal to the court when there is 5 minutes left per speaker. The court now invites counsel for plaintiff to begin.
Thank you. Good afternoon, justices, and to the counsel for the defendants that are here with us. My name is Alexandra Robbins, counsel for the plaintiff, and I'm joined by my partner, Owen Guinn. We ask that the court hold the defendants, Dr. Justin Lutzier and West Valley Memorial Hospital, jointly liable for Ms. Kyla Stark's death. The plaintiff is seeking $25.34 million in damages. We have 3 submissions to make before the court today. First, I will submit that Dr. Lutzier breached the requisite standard of care while treating Ms. Stark. Second, my co-counsel will submit that by failing to exercise reasonable care, Dr. Lutzier caused Ms. Stark's death in law. And third, he will submit that as Dr. Lutzier's employer, West Valley is vicariously liable for Ms. Stark's death. There are multiple elements of negligence at common law. Some of them are uncontested in this matter, and so I'll address them briefly first. First, with regards to duty of care, it's widely recognized in the jurisprudence that in relationships with supervision and control, such as doctor-patient, there is a prima facie duty of care. As well, with regards to damages, It's noted in Mustafa and Culligan that generally bodily harm will be sufficient to establish damages. Given that there was a death in this matter, this meets the threshold. Turning to the first contested issue before the court, we are in agreement with our friends that for medical negligence, the standard is that of a reasonable physician in the defendant physician's circumstances, and this is noted in Terneuzen and Korn. Now, more specifically, since Dr. Lutzier is a specialist in pulmonary and critical care medicine, the standard of care is more aptly described as the reasonable specialist in his circumstances. The issue before the court today is what this entails. What would a reasonable specialist have done in Dr. Lutzier's circumstances? To be clear, we agree with the defendants that supportive care is a customary practice in the medical profession for treating COVID-19 and that it was adopted by West Valley Memorial Hospital. We don't dispute that. We also agree with the defendants that typically adherence to customary practices will absolve a physician of liability. And this again is noted in Terneuzen and Korn. However, the plaintiff submits that customary treatments are not sufficient to establish a standard of care, especially in unique circumstances such as these. Physicians do more than simply provide treatments in that moment. And it's for this reason that there have been found to be breaches of standard of care where, for example, a physician fails to consult a patient's medical history, which occurs prior to treatment. Standard of care, therefore, is a holistic exercise, and it goes beyond mere treatment choice alone. One might look to a few places to get that more holistic picture of standard of care. One, we might look to expert testimony from other specialists in the field. And second, we might look to the practice guide laid out by the College of Physicians and Surgeons of Ontario, which lays out duties and obligations required of physicians that are governed by the college.
Counsel, can I just ask you a question? You mentioned Terneuzen. Is it your position that this is one of the circumstances mentioned in Terneuzen where we have a situation that is, to use, I think, the language from decision, something that's fraught with obvious risk, and therefore the court can make a determination of the standard in the absence of expert evidence?
No, Justice. Although there was an exception carved out in Terneuzen regarding negligent practices in and of themselves, we don't submit that that's what happened here. As I'll get to in my submissions, we submit that the negligence occurred in other areas of Dr. Lutzier's care, specifically his failure to collaborate with the patient, failure to transfer her, things like that. We completely concede that supportive care in and of itself is not a negligent practice. So it wouldn't fit into that particular carved out exception in Terneuzen. So turning to the breach of the standard of care, I'm now at paragraph 19 in our factum for those of you following. We submit that there was a twofold breach of the standard of care. The first would be the failure to review and assess the literature provided to Dr. Lutzier by Dr. Strange after he had asked for that literature. Now, our friends have submitted that since Dr. Lutzier supposedly had sufficient evidence to refute, as Dr. Moriarty had noted in his discovery would be sufficient, that there wasn't a breach of the standard of care. Yet we would submit that given the evolving nature of COVID-19 research, which Dr. Lutzier himself accepted or acknowledged at paragraph 112 of his cross-examination, that there is never sufficient evidence to essentially refute potential new research, and the obligation is an ongoing one. And this is reflected in Dr. Lutzier's conduct, where he asked for the literature that Dr. Strange was relying on. Turning next to the duties laid out in—
I have a question. Was it not an investigation of the literature for Dr. Lutzier to request copies of Dr. Strange's sources and then to subsequently deem those sources to be uncredible?
Absolutely, Justice, but we would submit that in this case, Dr. Lutzier didn't go far enough in assessing those to make that determination. In his cross-examination, he had described Dr. Strange as having sent him, I believe, 5 or 6 studies, yet she didn't send him studies, she sent him a meta-analysis, which suggests that he didn't even look closely enough at the email to assess the literature. Now, to be clear, this goes to a later point in my submissions. The plaintiffs are not suggesting by any means that Dr. Lutzier had to do a thorough review of every study published on ivermectin as it comes out.
Counsel, I got a question then. So against what standard do we measure his conduct? What amount of research is enough? Do you have evidence from an independent expert who wasn't involved with the care in this case that tells us what a reasonable amount of research in the circumstances would have been before proceeding with the care that Dr. Lucier was familiar with?
Well, Justice, we would submit that generally enough research would be enough to come to an informed conclusion. So, for example, Dr. Lucier made some of his own statements during his cross-examination. He stated, for example, that should he be faced with a scenario where a colleague were to send him studies regarding novel treatment options, that quote, he would engage in formal discussion with his colleagues, then read what they sent him in keeping with his duty as a medical specialist. And that since, quote, it's life-saving or claimed to be, you have to investigate. That would be his duty. So we would submit that, again, he notes that he would read the study. Meta-analyses generally have conclusions that sum up their findings at the end. So we would submit that a reasonable expectation of a doctor would be to at least look at the conclusion and get a general grasp on the results of that study. And that's what's so useful about meta-analyses is they compile and create an aggregate of multiple studies in order to create essentially easily digestible research. Turning to the CPSO's practice guide, there's 3 relevant duties here. And at this point, we're at paragraph 21 of the plaintiff's factum. The first is to collaborate with other healthcare professionals. This includes, for example, the exchange of information and shared decision-making. Here, Dr. Lucier did not engage with Dr. Strange after she had sent the literature. He asked her for the literature, and at that point, he had labeled it propaganda and chose not to look at it. There's also a related duty to learn, which includes seeking out new evidence and knowledge and keeping abreast of current developments in the field. Similarly, there's a duty to demonstrate professional competence, which includes demonstrating a sense of inquiry. Now, we absolutely concede that Dr. Lucier keeps abreast of research generally in his practice. He does hold monthly meetings. He has engaged in plenty of research review, and he helped develop the hospital's COVID-19 treatment plan. However, in this particular case, he was presented with materials that could have potentially informed his treatment decision. And this is where he ignored the research. So to be clear, the plaintiff is not submitting that Dr. Lucier has essentially engaged in a pattern of failing to demonstrate professional confidence or failing to seek out new evidence and knowledge, just that it occurred very clearly in this case after the material had been made readily available to him. And again, this is especially troubling given the fact that Dr. Lucier acknowledges the evolving nature of COVID-19 research.
Counsel, may I ask a question?
Sure.
It's John Granton. So professional practice is often guided by the council, but specific practice is often guided by specific protocols, which can come from, as you said, meta-analysis, but also in a rapidly changing environment, different governing bodies or professional associations, the CDC, for example, or the Ontario, in this instance, potentially the Ontario Science Table. And I would also ask you that in the hospital itself, did they have specific protocols in place? And also what was recommended by the Pharmacy and Therapeutics Committee, because there would be some standards that these individuals would have to adhere to as well in the care of these patients, specifically around administration of medications, which is strictly governed by the hospital when it comes to allied health professionals, perhaps administering these medications. There would be clear guidance. Do you have any sense as to what was available in the hospital at that time?
Absolutely, Justice. Well, from the record, what we do know is that supportive care is the standard treatment that is recommended by the hospital. And Dr. Lucier was involved in creating that treatment. To be clear, the plaintiff's submission is not that simply engaging in supportive care and adhering to this customary practice was negligent. That would, of course, be ridiculous. The submission here is that Dr. Lucier failed to take reasonable care at a few different steps throughout the process. So first, again, pointing to, as you mentioned, the evolving nature of COVID-19 research, he failed to investigate literature that could have influenced his treatment option. And it's important to note here that since, for example, ivermectin is approved for general use, albeit not specifically for COVID-19, the CPSO does give discretion to doctors to prescribe medication based on their own skill and knowledge. So that option.
So go ahead, you finished and I have a question for you.
Absolutely. So that option was open to the doctor, but as I will submit later as well, the plaintiff would also like to point the court to the fact that Dr. Lucier had the alternate choice when he realized there was essentially a breakdown in that patient-physician relationship to transfer Ms. Stark sooner to Dr. Strange's care. He did not have to administer Math Plus or ivermectin. Justice Sutton, I'm happy to take your.
Yeah, so you said could have. Is that what we're concerned about here? Don't we have to approach it from a different perspective? Is could have good enough for you to establish or breach the standard?
My apologies, doctor. The point I was trying to make by saying he could have is that Dr. Lutzier's hands weren't tied. There was a reasonable option available to him that he didn't take.
But do you have any evidence that he should have?
Well, absolutely, Justice. So if we look to, for example, again, those duties, one of the key ones is to collaborate and again, the duties to learn. So the issue here is that there was an initial breach of the standard of care by the doctor choosing to not read the literature. And at that point, it was very clear that the patient's family was displeased with the service. The patient's doctor, the primary care physician, was trying to contact Dr. Lutzier. And also the patient was not doing well under supportive care. She improved when ivermectin was administered and when Math Plus was administered. So given the circumstances and the way that things were unfolding with the patient, we would submit that in that case, the doctor had two options. He could have collaborated and agreed with the patient's family and administered Math or ivermectin. However, we also recognize that the doctor does have discretion and it's his choice whether or not to administer that unapproved treatment. And in the alternative, that's when he could have transferred the patient to Dr. Strange's care.
Counsel, can I stop you for 1 second?
Sure.
Are you asking us then to draw an inference that these treatments were effective just simply because of the temporal element in terms of when they were administered versus when these symptoms apparently were recorded? Is that what you're asking us to do?
No, Justice, that actually goes to my co-counsel's submissions, but I'll address it briefly here. So the plaintiff submits that there's two sources of evidence that we can draw from to establish causation. The first is general scientific literature. So my co-counsel will be reviewing some meta-analyses and studies regarding ivermectin to submit that generally there's evidence of its effectiveness. And second, absolutely, turning to a more patient-focused temporal approach, we'd submit that it is reasonable to establish that more likely than not balance of probabilities causation based on 4 separate reactions. The patient had ivermectin and Math Plus administered and removed. And each time there was a very drastic reaction, either to the administration with an improvement or with the removal, a decrease in her condition.
So bringing this back to duty of care, in essence, what you're asking us to do in this case is to apply an enhanced duty because you have conceded that the defendant met the standard of care in terms of the treatment that he prescribed. It was approved by his hospital. It had gone through the rigorous protocols in terms of approval at the hospital level. And so you're not suggesting that that treatment was inappropriate or substandard. But what you're saying is that notwithstanding that, he had a duty to go much further and review information that was sent to him by someone who I gather is not a specialist in this area. Is that what you're saying?
No, Justice, my apologies. I'll clarify. It's not the plaintiff's submission that the doctor met the standard of care. It might be perhaps a confusion with regards to semantics here, but we've conceded that supportive care is customary in the sense that it's standard practice, it's typical, it's commonly used. But standard of care refers to the more broad set of obligations and duties of a physician while caring for their patient. So, for example, that's why we see negligence in cases where, for example, a physician fails to account for a patient's medical history. That's not a treatment in and of itself. That's not the simple choice of a treatment, but there's actions that physicians take before treatment, during treatment, and after treatment, and all of these more holistically form the standard of care. So it's our submission that it's not negligence simply to have engaged in supportive care. The doctor's choices throughout the course of treatment in the aggregate were negligent. Turning back to the expert testimony that I had been mentioning, we can also look not only to Dr. Lutzier's statements, but also to Dr. Titchener's statements as well. And my apologies, I do see my time has elapsed. May I use the additional 5 minutes?
Can you clarify one quick point for me? I have a
Sure.
short answer to a question. So is it considered that physicians are responsible or mandated to follow their training, expertise, experience, evolving clinical knowledge, and review of the scientific literature when they care for a patient? Or are they responsible or mandated to follow guidelines and protocols from hospitals and societies? Which is it?
Well, Justice, we'd submit that it's a mixture of both. Hospital protocols provide a general standard practice for physicians to adhere to, but patients are different. Doctors are engaged in a service and they can essentially tailor that to patients. That's why, for example, when a doctor consults a patient's medical history, they may choose one treatment over another based on those patient's specific circumstances. So while the hospital's general guidelines are absolutely useful and may be used as a starting point, in particular situations, doctors do or are expected to amend their behavior and make choices based on that particular patient.
Thank you.
So turning to Dr. Titchener's quote, he said in his discovery that, quote, "You are, as ICU physician, left with the choice of watching your patient die or sitting down and reading a few studies. Standard of care here is you adapt to the situation, assess the patient, speak with the prescribing physician, do your own due diligence and make a decision." All of this, we would submit, suggests that in this case, reading the literature provided by Dr. Strange did form a part of the standard of care, and thus, since he failed to do so, Dr. Lutzier was in breach of that standard. Turning next to paragraph 30 of the plaintiff's factum, just briefly, we would also submit that there was a second breach, which was in the doctor's failure to administer Math Plus or ivermectin, or in the alternative, to transfer Ms. Stark promptly to Dr. Strange's care as soon as he realized he would not be administering those treatments. So for one, again, there is a duty to collaborate not only with other healthcare professionals, but also with the patient themselves. And we see a fantastic example of collaboration from multiple other physicians who were involved in the treatment of Ms. Stark. Dr. Papadopoulos, Nurse Patel, and Dr. Andy Park all collaborated with the family and with the primary care physician, and then ultimately agreed to administer Math Plus or ivermectin. Yet in both of those cases, after collaboration had occurred, which is in the duties laid out in the CPSO, Dr. Lutzier unilaterally intervened and took those treatments away without engaging in any collaboration. Moreover, we can look to the jurisprudence. So it's been noted that where a physician fails to take into account relevant facts at the time of treatment, that this may fall below the standard of care. So we would submit that a majorly relevant fact in this case was the patient's response to the treatments that she was receiving. Dr. Lutzier made no mention of or made no explanation for the fact that the patient was improving under ivermectin and Math Plus, and then when he removed, she would drastically decrease. Moreover, as was noted in Cuthbertson and Rasuli, that a physician may be considered in a breach of the standard of care where they choose to not provide a treatment that's called of medical benefit. Now, interestingly, medical benefit at law is a more patient-focused contextual approach. It's not a scientific inquiry. It looks to the patient's circumstances, the patient's condition, and their prognosis. So here again, and my co-counsel will elaborate on this, the patient was responding very well to ivermectin and Math Plus. So we would submit that she met the common law requirement of treatment of medical benefit, and thus him having withholded it was a breach. To conclude, justices, it's critical to note that the plaintiff is not attempting to hold Dr. Lutzier to a standard of perfection. We agree with the defendants that this is an inappropriate standard to hold him to. However, we submit that holistically, he failed to take reasonable care at multiple stages throughout the treatment process. First, by failing to read the literature. Second, by failing to administer that treatment of potentially medical benefit and actually going so far as to remove it once it had already begun administration. And third, by once seeing that the situation was not improving and that there was issues with the family and the primary care physician, by failing to provide Ms. Stark promptly and retaining care of her until she eventually passed away within an hour of her transfer. Barring any further questions, I'll now conclude so as to allow my co-counsel to discuss causation and vicarious liability. Thank you.
Good morning, justices. My name is Owen Guinn. I'm here today on behalf of the plaintiff, Mr. Sam Stark, and I'll be continuing submissions begun by my co-counsel. I have two submissions for this court today. Firstly, that Dr. Lutzier, by his negligence, caused Ms. Stark's death. And secondly, that West Valley Memorial Hospital, as Dr. Lutzier's employer, should be vicariously liable for his negligence. In order to demonstrate causation, my first submission, and I'm now at paragraph 40 on the plaintiff's factum, it is necessary to show on a balance of probabilities that it is only more likely than not that but for Dr. Lutzier's negligence, Ms. Stark's death would not have occurred. This is the standard laid out in Clemens against Clemens. In order to do that, the plaintiff will look first to a number of studies which show the effectiveness and safety of ivermectin in decreasing rates of mortality in patients with COVID-19. These studies can be found at paragraph 41 through 43. The first of these meta-analyses is the one provided by Dr. Strange to Dr. Lutzier in the email at his request. This meta-analysis contained a review of 78 individual studies, which together found a notable 44% reduction in patient mortality when treated with ivermectin, with a further noted high degree of statistical significance. But the plaintiff admits that this one meta-analysis alone may be insufficient to demonstrate causation on a balance of probabilities. So we also look to another of other studies, the first of which being one conducted by Cobos Campos et al., which is a meta-analysis of a further 53 studies and 17,500 patients. It found a further 81% reduction in mortality in patients treated with ivermectin, with results so statistically significant that they estimated that the chances of an ineffective drug yielding the same results merely by coincidence were as low as 1 out of 167 trillion. And finally, for the last study to mention here, Santin et al., when referring to 7 randomized control studies, also noted a phenomenon in Peru in which, after a state-sponsored mass administration of ivermectin, COVID-related deaths decreased 14-fold. And when that program was then ended, COVID-related deaths increased again 13-fold. And the study accounted for and ruled out potential confounding variables.
Can I ask you a question? These studies are all very interesting, but has an expert helped us understand what these mean in the specific context of this case? Because filing studies, that's all hearsay. So what are we supposed to do with these studies absent an expert interpreting it to assist the court?
Certainly, Your Honor. And in fact, the plaintiff does acknowledge that many of these studies contain some poor methodological results or evidentiary results within the studies contained in the meta-analyses. We do not use these as exhaustive evidence that meta-analysis would have saved Ms. Stark's life. Instead, we use them primarily to show that there is an existence of significant data that demonstrates that ivermectin could be substantially significant for improving Ms. Stark's chance of survival. However, we are also, in addition to that, able to rely on Ms. Stark's individual response to ivermectin and how the administration and removal of the drug changed her condition individually.
Isn't that just coincidence? Like, we have evidence from a physician that, in fact, or even just on a more likely than not basis, that it was the intermectin, I'm gonna pronounce that wrong, anyhow, that was the actual factor that caused her improvement as to some other factor that may have been present at the time?
Your Honor, because the test at common law is merely establishing balance of probabilities, we must go with the common sense, most likely interpretation of what would have caused Ms. Stark's change in condition. The facts are that on the first challenge of the drug, the administration of ivermectin, her condition improved. When the drug was re-challenged, that is to say it was removed, her condition immediately declined. She had to be ventilated and placed in a medically induced coma. And when finally the drug was de-challenged again and administered for a second time, the Math Plus protocol, her condition then improved again, and she was able to be brought out of her induced coma and rely only on a nasal cannula for supplemental oxygen. This direct result and change in condition in response to a drug in 4 separate occasions when it was given and then removed does go so far as to establish that it is more likely than not that we should look to the most likely explanation for what would have done that. And given the direct correlation between administration and approval, this establishes on the balance of probabilities that it's more likely than not that that ivermectin was thus having a true drug effect and was the cause for her change in condition.
So are you saying that the balance of the evidence, meaning not only her case and her course and her discrete multiple temporal associations with administration and improvement, that's also in line with 50 to 70 studies showing consistent, reproducible, large magnitude improvements in mortality and benefit. So because that's the balance is why you're making that argument?
Those two things taken in combination together and applied to Ms. Stark's case, we argue that yes, do shift the balance towards being more likely than not. Now, the defendants will point to sources such as the CDC and the Georgia Bay Family Health Team to suggest that in fact, Ms. Stark's change in condition was merely coincidence and was consistent with the normal progression of COVID-19. And I'm now at paragraph 42 of the defendant's factum. They suggest that because of this and sources that say that some patients who may have slightly started to feel better at day 7 may then deteriorate and feel worse afterwards, this means that Ms. Stark's change in condition was actually only due to the progression of COVID-19. However, that is not actually consistent with Ms. Stark's real response to how her disease and how the drug was treating her. That source contains only a small mention that patients who at that period may have started to feel slightly better may then continue to get worse. It does not account for the extremes of change that Ms. Stark experienced when she went from a medically induced coma to relying only on a nasal cannula for supplemental oxygen. It also doesn't note for the fact that Ms. Stark improved not once, but twice after administration of the drug. And this is not at all consistent with the normal progression of COVID-19 in most patients. Therefore, we should look, again, to reiterate my point, to the most likely explanation. And when we have a drug that had direct effects twice and direct effect twice again when it was removed, it suggests that it's more likely than not that that drug was the cause for her improvement. Furthermore, we submit that ivermectin itself is a safe drug and would not likely have caused any of these adverse effects itself. 90,000 prescriptions of ivermectin are written in the United States every week with no indication of a changing rate of adverse health effects related to it. All studies as to trying to establish adverse effects from ivermectin's use rely on when the drug is given at toxic doses, at doses intended for animals or veterinary care. When ivermectin is given at its proper human dose by a doctor's prescription, as Dr. Lutzier should have done in this case, there's no evidence to indicate that there is a chance for adverse health effects.
Council, can I interrupt you for a second? I'm having trouble with the chain of causation here. As I understand, one of the central allegations, the defendant failed to meet the standard of care because he did not review the materials that were provided to him. And in fact, he'd asked for, I get that. And I hear your argument that statistically, there's evidence that suggests the potential benefit. But do you not have to demonstrate to this court evidence that had the defendant or a reasonable, prudent physician in his circumstances or her circumstances reviewed this materials, they would have embarked upon treating with this protocol? Do we have that evidence? Because I haven't seen it in any of the materials that's before me.
Respectfully, Justice Dowd, that evidence is not necessarily required here because of the third option that was open to Dr. Lutzier. Had he reviewed, as he should have done, the information provided on ivermectin, and then made the decision not to administer the treatment of ivermectin, he could then have also transferred his patient to Dr. Strange, who then could have administered the drug. Thus, the chain of causation is established given that had Dr. Lutzier met his duty of care in all aspects of his duty, Ms. Stark would have had the drug administered to her, and she would then, more likely than not, have survived. We understand that the correlation and the does not necessarily mean causation in this case, but to reiterate, 4 separate instances do establish that it is more likely than not that the most obvious explanation is truly the case here. Scientific precision is not required, but the studies taken on one hand and Ms. Stark's individual response to the drug on the other do establish that but for Dr. Lutzier's negligence, it's more likely than not that Ms. Stark would have survived.
Counsel, can I ask a question? You're taking a strong stance that there's a temporal relationship between either giving or not giving the drug and the patient's response, and you're assuming that that time frame was within a period of hours. What if the time frame was longer and you're in fact looking at the effects 36, 48 hours later, and in fact the drug equally could have been causing harm? And the other premise you're hanging on to is a meta-analysis, which, like a lot of scientific literature, is susceptible to interpretation. And in fact, many of the studies you're quoting have been recently redacted as well from the scientific literature. So I think that I'd like to hear your comment on both of those points.
Certainly, Your Honor. As to the time frame issue, because of its significance in this case, we've reviewed it and made a determination as to what we argue it establishes on the balance of probabilities. Were the time frame to be different, the argument would be different. We would have to re-review and reassess what that indicated about Ms. Stark's condition. However, in this case, because the time frame was what it was, the results and her change in condition were so significant and so clearly related to coming directly after the administration of the drug, we do argue that it establishes a more likely than not causation. Now, I'm sorry, Your Honor, could you just repeat your second point of the question for me again?
So it's basically hinging on the reliance around the scientific literature, which is relying on a meta-analysis, which is an interpretation or summary of the literature. A lot of those studies, or some of those studies, have since been redacted as well, or retracted from the literature because they were either falsified or incorrect. So I think it would be important, and other judiciary have commented on this, to have the interpretation, which, as I understand it, would rely more at the level of the CDC or scientific review beyond at a given physician level, where he or she may not have that sophisticated insight into the conduct of things like a meta-analysis.
Certainly, Justice. And respectfully, the meta-analyses that we have relied on here, none of which have been retracted or changed, although we do understand some meta-analyses in the past have been redacted, we do not specifically rely on those in establishing causation. Secondly, we understand that groups like CDC or Health Canada make these interpretations of meta-analyses. However, this is a rapidly changing environment, and the science is consistently coming out that goes to studying ivermectin and its effectiveness in COVID-19. Unfortunately, many of these groups are somewhat limited by, one, reviewing all of the data as it comes out, and then having to make generally applicable statements about ivermectin. We are not limited to the same extent because we only need to make applicable statements about one patient. And therefore, these meta-analyses, when combined with the statements we have to make only about this one patient and what caused her death, does again demonstrate that ivermectin in her case was more likely than not an effective solution. Now, I see I'm running low on time. Might I request my additional 5 minutes?
You may.
My second submission for the court today is vicarious liability. And I'm now on paragraph 51 of my factum. In order to show vicarious liability, the common law test, the Salomon test, is that the plaintiff must show that an employee's wrongful conduct must consist of either, one, acts authorized by the employer, or two, unauthorized acts that are so connected with acts that the employer has authorized that they may be rightly regarded as modes, although improper modes, of doing what has been authorized. And therefore, we argue that West Valley Memorial Hospital should be held vicariously liable for Dr. Lutzier's actions. Going to the first stage of this test, which we submit is the most relevant here, were Dr. Lutzier's actions authorized by West Valley Memorial Hospital? The facts are that Dr. Lutzier was a paid employee of the hospital who also assumed risks for anything he might bring up in his job. And in addition, his actions, as he admitted in his deposition, were on behalf of the hospital, not himself. Therefore, his decisions to not administer ivermectin, to not read the relevant literature, and to not transfer his patient when it became necessary to do so were, while negligent, also authorized by the hospital, as they had given him the power to make those decisions. There are policy benefits to findings of vicarious liability. They are generally that it helps to provide adequate remedies to the plaintiff, and that it incentivizes employers to prevent negligence. These policy benefits would be fulfilled here by finding a vicarious liability. The $25.34 million that the plaintiff is requesting could help be supplemented by the hospital's resources. And in addition, it would help ensure that hospitals do not allow their physicians to act alone without regard to the duty of care that Dr. Lutzier demonstrated in this case.
Counsel, I have a question. Do we have evidence that the doctor was an employee rather than simply having privileges to practice at the hospital?
Yes, Justice Sutton. By his own admission, he admitted that he was a direct and paid employee by the hospital, and that therefore the hospital would be liable for any negligence that he brought on while in the commission of his duties to them.
What was the hospital's official recommendation for ivermectin, and was it available on their formulary, or had they removed it?
The hospital's official recommendation for treating COVID-19 patients was to administer the protocol, which was not to administer ivermectin. However, and that would have been available to him.
In any circumstance, they recommended not to use it?
They did not recommend for the use of ivermectin in treating patients with COVID-19. Of course, it could still be used for its anti-parasitic effects.
There's a difference between not recommending and recommending against. Which was it?
It was not they did not recommend for its use. They did not say that doctors could not use it or should not use it.
Okay.
Therefore, in this case, it is fair for a hospital who employs a physician for their own financial gain to thus also assume risk for negligence brought about by that physician in his actions for the hospital. Therefore, the plaintiff argues that West Valley Memorial Hospital should be vicariously liable for the negligence of Dr. Lutzier. Based on these arguments and the arguments of my co-counsel, we ask that this court hold Dr. Lutzier liable, West Valley Memorial Hospital vicariously liable, and award damages to the plaintiff in the amount of $25.34 million. Barring any further questions, this concludes the submissions by the plaintiff. Thank you.
The court now invites counsel for the defendant to begin.
Thank you. Good afternoon, Justices. My name is Kahlon, and I'm here today with my co-counsel, Nicole Davidson. We are counsel for the defendants in this matter, Dr. Justin Lutzier and West Valley Memorial Hospital. I will address the requisite standard of care. My co-counsel will then make submissions on causation and vicarious liability. Altogether, our submissions will demonstrate that while this was a very tragic outcome for Kyla Stark, the court should find that there is no liability for negligence in this case. Especially during a global pandemic, we submit the court should not set a precedent where healthcare heroes fear being accused of negligence for following the accepted standard of care. My submissions have three main points. One, the requisite standard of care for medical negligence in Canada is the standard of the reasonably prudent doctor. Two, Dr. Lutzier did not breach the standard by choosing not to review the literature provided by Dr. Sophia Strange. And three, Dr. Lutzier did not breach the standard by declining to treat Ms. Stark with Math Plus or ivermectin alone. My first point sets out the requisite standard of care as it applies in this case. It is established that the standard of care for doctors is to conduct their practice in accordance with the conduct of a reasonable, prudent, and diligent doctor of the same experience and standing. When a doctor presents themselves as a specialist, they are held to a higher standard than a general practitioner. In this case, the degree of care, skill, and knowledge required of Dr. Lutzier was that of a similarly situated and experienced pulmonary and critical care specialist. It is crucial to remember that the standard of care does not expect perfection from our doctors. Rather, the standard is one of reasonable care. We submit that the counsel for the plaintiffs have not met their burden to prove that there was a breach of the reasonable standard of care. Dr. Lutzier exercised reasonable care in his treatment of Ms. Stark, as expected of a reasonably prudent pulmonary and critical care specialist. Moving to my second point, Dr. Letzier did not breach the standard of care by choosing not to review the provided literature, as he had a good reason to not examine the data, which is the standard of a reasonably prudent and diligent doctor. In fact, Dr. Kahlon Moriarty, who has significant experience working in the ICU during the COVID-19 pandemic, stated it would be strange for a doctor to not investigate the provided literature unless the doctor had solid evidence to refute the studies or another good reason to not examine the data. In their submissions, my friends state that since Dr. Letzier asked for the literature, he did not have sufficient knowledge, but respectfully, we do not agree. Dr. Letzier was aware that the evidence in support of ivermectin is lacking, and that many leading medical societies, such as the National Institutes of Health, have determined that the studies on ivermectin are insufficient. The main concern is that most of the studies in support of ivermectin are flawed due to significant limitations. Dr. Letzier was aware of these limitations. Furthermore, Dr. Letzier has a monthly meeting.
Because I have difficulty with that. If he was aware of the limitations of this material, why did he solicit it from the treating physician? And I appreciate that you, in your factum in paragraph 20, you talk about the exercise of clinical judgment. And I understand that. But does the exercise of clinical judgment not require you to review the information that's available to you, but more so when you elicit it from a physician who has also provided care to that patient?
Thank you, Justice. So I understand the point that you're saying. However, we submit that we cannot judge doctors in retrospect. So in that moment, he might have requested that literature and then felt that it was an unreliable source, especially coming from Dr. Strange, who was asked to step down from her position at Fallview Health and also received a warning from the CPSO for treating her COVID-19 patients with ivermectin. So he may have requested that literature, but then later changed his mind. And we cannot judge that decision in retrospect. Furthermore, Dr. Letzier has monthly meetings with a team of experts.
I was muted. Are you saying that he didn't review the literature because he did review the literature and determined that it was unreliable, or he didn't review the literature? Because it's a little confusing.
Sorry about that. So to clarify, he did not review the literature provided by Dr. Strange specifically. However, as I was getting to my next point, he does review the literature monthly with a team of experts,
so he
especially.
Predetermined that that literature was unreliable.
Yes, so in his monthly meetings, Dr. Letzier with this team was reviewing all of the high and medium quality evidence overall for COVID-19. So we submit that if the literature that Dr. Strange provided did include high or medium quality evidence, it would have already been reviewed by Dr. Letzier and his team.
So the determination, you made a statement just now that most of the studies are flawed. So you're talking about 78 controlled trials from centers, countries around the world, and most are flawed. So where does where is that statement substantiated? And also, can you provide me evidence of any study without flaws? Ever?
So that information is from the National Institutes of Health, and they have made that determination that there are a lot of limitations in the studies on ivermectin. Unfortunately, I cannot give you a study that doesn't have any flaw, as I'm not aware of that information, unfortunately.
Okay. Well, this brings up a very important question, which I don't want to derail your testimony here, but have you ever heard of the phrase regulatory capture?
No, I cannot say that I have.
Okay, so you don't know of instances where public health agencies like the NIH fall under the control of financial interest or corporate interest, and their behaviors and reviews and or recommendations are highly influenced by those without scientific objectives? Are you aware of that? Ever happened?
I have heard of that.
In the environmental, Department of Environmental Protections, water safety, quality, going on and on. You have heard of that?
I have.
Okay. Was that ever considered in trying to understand why all these recommendations conflict from scientists and groups and meta-analysis and authors without conflicts of interest and or agencies which are highly prone to regulatory capture?
Although I do understand that that is a very significant issue in the science community, we respectfully submit that that is not an issue that the court has to deal with. That is not an issue that we must address before this court. In this situation, we have to recognize this evidence that was provided to us. That includes the expert evidence and the science. And we do look to those federal health organizations because that is their purpose. That is what the courts have relied on in the past. They do recognize that while expert evidence is also appropriate, that it's also appropriate to look at national and international recommendations.
But I would ask the question. So I like your answer there. So it is appropriate to provide the science and review the science and critique the science. So you can do that for meta-analyses. Do you think it's appropriate to also question health agency determinations and look critically at the science that they rely and or subsets or really actually very small amounts of relevant evidence? Does it go both ways or it's just in the public literature?
You make a very good point, and I do agree that that is something that should be looked further into. But at this point, we do not have any say to make those determinations at this court for the issues at hand in this case.
But you're submitting that when you cite as the highest level of sort of recommendation and knowledge, you are saying that these agencies that you just cited, that would be the bar over which takes all precedence. Is that sort of how I'm understanding how we should proceed looking at the evidence? So when the NIH or FDA or any relevant Canadian society comes up with a determination recommendation, that's the highest level of and strength of recommendation. So when they say most of the studies are flawed, that is an unalterable, unassailable truth.
Definitely not, Justice. And it is a situation where you have to look at it as one factor. You also look at expert evidence and you look at the facts of the case. It is a determination where the court has the responsibility ultimately to determine the standard of care by weighing the evidence that we are putting forward.
Okay.
Council, I just have one follow-up question. Justice Corey made a point about, just to clarify, whether or not the requested information was ever actually reviewed by Dr. Luzier. And the information that I have, and correct me if I'm wrong, is that subsequent to receiving that information from Dr. Strange, Dr. Luzier deemed it to be propaganda. And so I'm wondering on what basis he said that if he did not look at it at all. Was it by virtue of the fact that he decided he had seen everything he needed to see in the literature based on his monthly reviews, or was there something that he based that remark on?
We do recognize that it was not an appropriate statement for Dr. Luzier to classify that literature as propaganda. However, besides looking at the choice of words he used, the ultimate thing that we should look at is that he was reviewing the literature monthly, the latest literature monthly, not just him, but with an interdisciplinary team. And that's what it comes down to, is that he made that determination. And we also conclude the same, that if there was the high or medium quality evidence on Math Plus or ivermectin, he would have been aware. And he was also aware of what other federal health organizations are saying about those treatments.
Council,
so just to clarify, he called it propaganda without looking at it at all.
It is to my knowledge that he did briefly skim it or briefly look at it, but he did not look at it in detail. That is correct.
Council, in the past, when international and national healthcare organizations develop guidelines and recommendations around medicines, has it been standard practice to only include those studies that are of quote unquote high or medium quality, or are all studies considered knowing their caveats and in order to inform a recommendation, which is the low, medium, high?
It is to my knowledge, and this is just based on the information that I have looked through, that actually I can't actually speak to the other organizations, but I did look at Health Canada. And when Health Canada is making determinations about the treatments that they approve, such as for COVID-19, they rely on high quality evidence. And Dr. Luzier had also stated in his testimony that it is often that you rely on the high quality evidence to determine like the hospital policy, but you could also even look at medium quality evidence. So they did even assess that, but it was not something that they would look at the low quality evidence.
So they specifically exclude studies that are deemed to be of, it's really not quality, but it's of high risk of bias or low risk of bias. So they exclude all those. Okay. Is that correct?
Correct. They only look, pardon me?
Okay, that's fine.
Hi, it's Jamie Spiegelman here. Besides the evidence and that you're talking about in terms of literature or meta-analysis, did the doctor ever mention standard of care in terms of what the College of Physicians would recommend, what the Health Canada and FDA would recommend?
It is to my knowledge that that was not recommended, so I cannot speak to that particularly. However, unless you have a follow-up question.
No, it's just physicians work within a system that is based on these like these colleges and authoritative guidelines, right? Besides the evidence, these organizations tell us how we should treat patients under the standard of care. And at the time of this case, the CPSO, as well as Health Canada and FDA, had certain guidelines. Was this physician aware of those and following those guidelines?
Actually, yes, sorry, I do want to make a correction to my previous statement. So one of the CPSO duties, and my friends mentioned that as well, is the duty to learn. And that is a key duty that my friends brought up. And we submit that the actions of Dr. Letzier showed that he had a desire to be up to date on the latest literature, and that was the standard of care, that he followed like a reasonably prudent and diligent doctor to be up to date on the latest literature that he reviewed with an interdisciplinary team on a monthly basis. Now, as I stated earlier, the standard of care is not a standard of perfection. We submit that Dr. Letzier cannot be required to read all the studies provided to him, even if he requests that literature. Dr. Letzier cannot be held to a standard of perfection where he must read every study or every meta-analysis every time it is sent to him. This is simply not possible, especially during busy times such as the COVID-19 pandemic. At worst, Dr. Letzier's choice to not review the provided literature can be classified as an error of judgment, and that is not sufficient to establish a breach of the standard of care. Dr. Letzier made a reasonable, intelligent decision to prioritize the care of his patients using the hospital's COVID-19 treatment guidelines, which again, I want to reiterate, was established by a team of experts and reviewed monthly. It cannot be said this decision was an act of carelessness or unskillfulness. To conclude my first point, Dr. Letzier's choice to not review the literature provided by Dr. Strange cannot be considered a breach in the standard of care. Moving to my last point, it is generally accepted that doctors will not be found liable for negligence when their actions conform with the respectable and recognized practice of the profession. The only exception to this is when it can be established that the common practice itself is negligent. However, this requires obvious risks or dangers associated with the common practice that can be understood by the ordinary person. Dr. Letzier followed a course of treatment known as supportive care when treating Ms. Stark. At the time and to this day, supportive care is recognized by medical science as being an appropriate treatment for COVID-19. Supportive care is a part of the hospital's COVID-19 treatment guidelines, and it includes drugs such as remdesivir, which is the only drug approved by the FDA to treat COVID-19 in hospitalized adults. Health Canada has also authorized the use of remdesivir as a treatment for COVID-19, and Health Canada only addresses treatments after a thorough scientific review.
Can I ask the council to clarify? I think you just defined supportive care in a different way than I'm used to the definition. So supportive care is just support of symptoms and treatment of symptoms. There's not a specific disease-directed therapy, but you were including remdesivir in supportive care, or did you mean standard of care?
So I did include remdesivir in supportive care. I understand where you're coming from, Justice. This was supportive care name comes from what was provided in the facts. It's a list, it's 9 steps that includes the administration of oxygen through a nasal cannula at night, nasal cannula during the day, BiPAP at night, dexamethasone, remdesivir. It's a list of steps. All of those
things are supportive. All of those things are supportive, but remdesivir is a therapeutic. It's a specific therapeutic for a specific disease. That doesn't fall under general supportive care. Is that correct?
Correct in that understanding, but just in this case, that's how it was described in the facts, in the agreed upon facts. Leading societies in medicine and federal health agencies recognize supportive care as the standard of care. This is strong evidence that Dr. Letzier adhered to the reasonably prudent standard. Moreover, there are no obvious risks or dangers associated with supportive care to show that the standard itself is negligent.
Question.
is council aware that even though the FDA and the NIH approve remdesivir as a quote standard of care, is council aware that the World Health Organization disapproves of the use of remdesivir since November 2020, well over 1 year ago, suggesting that there is no benefit at any stage of the illness? Is council aware of that?
Yes, I was aware that that is a conditional recommendation. However, in this case, it is known that the hospital and Dr. Letzier rely on other institutions such as Health Canada, FDA, and NIH, but I was aware of that. Dr. Strange and Dr. E.B. Titchener may argue that the standard of care in this case was the administration of ivermectin and the other components of MAP Plus rather than supportive care, but it is important to consider the scientific evidence. The FDA may authorize unapproved drugs or unapproved uses of approved drugs under certain conditions due to the emergency use authorization. Currently, 14 COVID-19 treatments are authorized for emergency use, but ivermectin is not one of them. Both the FDA and Health Canada have not authorized or approved the use of ivermectin for treating COVID-19 because they state the current evidence does not show that it is safe or effective. As
Can I
such,
correct you on that? So we're going from, they're saying not to use it because the evidence, the quality of evidence isn't high enough. Are they saying that it's not effective? Because almost all studies find benefit. I've been hearing you say that it's not recommended because the level of evidence of that benefit is low. Is there any evidence to show that it doesn't work? That it actually shows harms or doesn't work? Is there any trials that show that it doesn't work?
although I'm not aware of any specific studies, these are statements that the FDA and Health Canada both released, that their reason for not recommending or approving, I should say, ivermectin, is that the evidence doesn't show that it is safe or effective. These are statements made by those organizations.
Okay. And then can I ask you a question about this? You're arguing about standard of care. And we heard from opposing counsel about some of those elements that constitute standard of care as per the College of, I think it's Physicians and Surgeons. Then there's this common law citation that they made, which is that, it violates the common law if you choose not to provide a medicine that's of benefit. Now, I am understanding that when doctors practice medicine, generally their patient should be their primary consideration. And when you talk about the potential risks and benefits of any intervention, they would change as the disease course changes. And so do you think it was a failure of the standard of care for a specialist who's taking care of someone who's deteriorating and dying to stay the course, stick to the standard, stick to the protocol without considering any other things that could be of benefit? So is that what all the doctors are doing in that area, is they do not stray from protocols no matter the response of the patient? Or do you think that might be a violation of the true responsibility of a physician to their patient, which is to do what they can to keep them alive, to bring them of a benefit? Or is it the standard of care is established by how much they adhere to whatever protocol is being recommended?
Thank you, Justice. We do submit that there is a balance, and that is an important balance. It's a thin line that you have to address. And ultimately, we have to rely on something, and that's why we rely on hospital policies. Even the CPSO guidelines that stated that the standard of care during a pandemic is for a doctor to practice in accordance with the Ministry of Health, CPSO, and hospital policies or procedures. So while it is—
Even when a patient is failing and the advocates of the patient are trying to advocate for more attempts at medicines that have large evidence bases, that have unparalleled safety profiles, it's most important that they stick to the protocol and ignore what the benefits or outcomes or impacts are on the patient.
Although
they ignore that and stick to the protocol, that would be keeping within the standard of care of physicians in Canada?
No, that is not correct. And I do want to speak to this specific situation specifically, because we do recognize that there were two situations where Ms. Stark did improve after getting MAP Plus or ivermectin. However, we also recognize that correlation does not equal causation. And my co-counsel will be addressing this further in her submissions, but there are possibilities that by giving ivermectin and Math Plus, even though there was a benefit for a short amount of time, that it might have actually led to the further complications that we saw.
It's Jamie Spiegelman here again. Now, did the hospital or the doctor actually look at what the other standard of care practices were at the time? Because at this time, while the patient's on a ventilator, I would argue that remdesivir is not the standard of care. There's other treatments like tocilizumab and other medications that were the standard of care. Did the hospital look at their protocols and update their protocols related to that? And did the doctor consider those?
So as I mentioned previously, the hospital policy was updated monthly based on the evidence. So most recently, before Ms. Stark's passing, that hospital policy was updated about, I would say, a month prior. And that was the most recent update based on the most recent evidence that was available at their last monthly meeting.
Counsel, one more question. A part of this case that you've mentioned is that there was a refusal or failure to provide the Math Plus protocol. Can you tell me how many how many different therapeutics are involved in the Math Plus? Is it just ivermectin?
No, there is many different components of ivermectin, and most of the components are actually, I will correct myself, some of the components have been studied by the National Institutes of Health, such as nitazoxanide, vitamin D, fluvoxamine, and zinc. And those 4 components were studied in relation to COVID-19 specifically. And it was found that either it was a recommendation against using it or there was insufficient evidence. So we do recognize that ivermectin is not the only component, and there is some research for the other components as well.
And you mentioned the ones that they didn't recommend. What are there any others that that are in that protocol that are recommended?
From my research on the NIH, that heparin was recommended, and that is a part of the Math Plus protocol.
Was that being given to the patient?
To my knowledge, no.
What about corticosteroids?
Dexamethasone was being given to the patient.
Okay.
Counsel, I have a question. When in talking about standard of care, the plaintiff's counsel had mentioned that standard of care or negligence had taken place because although standard of care based on hospital policy was applied in the protocol treatment of the COVID-19 management for this patient, negligence applies here because the doctor did not personalize the treatment to the patient's specific needs. Could you please address that from your perspective? And do you feel that that this is in fact the case, or is it defensible?
We do recognize that, for instance, collaborating with the patient and family is important. It is a duty of doctors. However, there is a line with collaboration. Now, this was not a situation where there were 2 approved treatments where Dr. Letzier could collaborate with the family to determine which treatment they would prefer. No, this was a situation where there was 1 approved treatment that is backed by federal health agencies and another treatment that has components that is not approved or authorized. And so when this is a situation where we would say collaboration is not appropriate.
It's like I'm gonna come full circle with the question I asked your friend. What do you say the law allows us to do on the basis of the Ternoisen decision in the absence of expert evidence before this tribunal, this court, to determine the issue of whether or not the standard of practice was met?
Thank you. The Supreme Court has held that a doctor will not be found liable for negligence if the treatment provided to a patient corresponds to what is recognized by medical science at the time, even in the face of competing theories. And now that is the key point. So essentially, courts should not become involved in controversial questions regarding the treatment of preference, which is really what we're seeing here today. So in light of the competing theories regarding the treatment of COVID-19, we submit that because Dr. Letzier chose supportive care, that cannot be considered a breach of the standard of care. Okay. We cannot deny that the death of Ms. Stark was a terrible tragedy, but Dr. Letzier had every reason to believe he was making the right choice in treating her. To conclude my submissions, we respectfully submit that Dr. Letzier did not breach the standard of care by choosing not to review the literature provided by Dr. Strange. Further, we respectfully submit that Dr. Letzier is not liable for medical negligence as he chose to follow the hospital's COVID-19 treatment guidelines and use supportive care. Subject to any further questions, that concludes my submissions.
Yeah, just last one. You know, the comment about propaganda. So you just said that he had every right to do what he did and not listen to the evidence because he determined it was propaganda. So you're forgiving him that statement. What is not factual about that statement, that he dismissed the literature, published literature, medical journals that were peer reviewed? Why is that an incorrect statement that he made? It sounds like that was in keeping with his beliefs, that he dismissed it as propaganda. And what is propaganda?
We do agree that Dr. Letzier's choice of words were not appropriate. However, as I mentioned previously, his choice to not review that literature at worst can be classified as an error of judgment. And in law, an error of judgment is not sufficient to establish a breach of the standard of care.
Inappropriate use of a term, is it also incorrect to say that it doesn't reflect his beliefs? Are you saying it didn't reflect his beliefs, it was just an inappropriate wording? Or he believed it was propaganda and said it was propaganda, which he felt it was non-scientific. It had no basis in science, and it had some ulterior purpose to convince people of ivermectin. So these were studies put together by nothing but fraudulent scientists trying to convince the world of using one of the safest, oldest, cheapest, and most effective drugs of any disease model in history?
Although I cannot speak to Dr. Letzier's personal thoughts and opinions about when he did choose those words, we would recognize that he did review the literature, the other literature, not just alone, but with a team of experts and an interdisciplinary team. So regardless of what his personal views are, I cannot speak to them. I'm not sure why he used those words or what his thinking was. Overall, regardless of whether it was ivermectin or supportive care, he was reviewing the literature overall in general with a team of experts.
Okay.
Okay. My co-counsel will now address the remaining two issues.
Good afternoon, Justices. My name is Nicole Davidson, and I will be dealing with the final two issues on causation and vicarious liability. I have 2 points on my submission. First, Dr. Letzier did not cause or contribute to Ms. Stark's tragic passing. And second, the hospital cannot be found vicariously liable because Dr. Letzier met the standard of care. My first point sets out the applicable test for finding causation. I will also consider the facts of this case and the relevant medical literature to demonstrate why causation has not been proven on a balance of probabilities. Even if this court determines that Dr. Letzier breached the standard of care, we submit that he is not liable in negligence because the plaintiffs have failed to meet their burden of establishing a factual causal connection between Dr. Letzier's actions and Ms. Stark's death. Factual causation is established by applying the but-for test. The plaintiff must prove that the harm would not have occurred but for the negligence of the defendant. The plaintiff carries the burden of showing that it was more likely than not that adequate treatment would have prevented the outcome. It is not enough to show that adequate treatment would have afforded a chance of avoiding the outcome unless that chance passes the threshold of more likely than not. This court bears the responsibility of determining whether the plaintiff has met his burden of proving causation on a balance of probabilities. We maintain that our friends are unable to prove on a balance of probabilities that but for Dr. Letzier withholding Math Plus or ivermectin, Ms. Stark would have survived. Even if Dr. Letzier had read the studies provided by Dr. Strange, it is unlikely that he would have changed his course of treatment. When Ms. Stark was admitted to the hospital, she was experiencing what are classified as moderate to severe COVID-19 symptoms with severe shortness of breath and a mild hypoxia. The studies provided by Dr. Strange are inconclusive regarding ivermectin's efficacy in treating moderate to severe COVID-19. The National Institute of Health has considered most of the randomized control trials on ivermectin and has identified key limitations for each. These studies are insufficient and do not speak to the efficacy of treating severe COVID-19 symptoms with ivermectin. Our friends rely on various studies regarding the use of ivermectin to treat COVID-19 in an attempt to prove that Dr. Lutzier caused Ms. Stark's death by withholding this treatment. However, I respectfully maintain that these studies are insufficient to reach such a conclusion. The studies provided have various limitations, including studies of ivermectin's use in the prophylaxis stage.
Counsel,
Yes.
I would agree with you about these studies, and I would agree with you that Dr. Lutzier could have relied on the more prominent and better peer-reviewed studies, the high-quality ones. I would agree with you, except for in the case of Ms. Stark, she responded so well when the ivermectin was given on 2 to 4 occasions. I have now lost track of how many, but at least twice. She was given ivermectin. She personally responded extremely well, coming off intubation, being only on room air. And then as soon as the ivermectin was not administered in a subsequent dose, her health declined again. And that happened repeatedly. So how can Dr. Lutzier say that what a common person can see is that the ivermectin was beneficial for this patient and therefore should have been continued? How do you respond to that?
This actually brings me to one of my later points that I wanted to speak to that, because we do submit that correlation between Ms. Stark's condition improving and treatment with ivermectin and Math Plus is not enough to establish causation. So twice in the course of her stay at the hospital, physicians stopped the standard treatment plan and did provide either ivermectin or Math Plus protocol to treat Ms. Stark. However, the facts here show that ivermectin was administered to Ms. Stark on day 6 after onset of her COVID symptoms. Her symptoms did temporarily improve, but then the next day she was placed on a mechanical ventilator for the first time. She again improved after Math Plus was administered around days 9 to 10, but she deteriorated around day 12 and was placed again on a mechanical ventilator. Now, the Math Plus literature that was provided by Dr. Strange to Dr. Lutzier states that Math Plus should be administered soon after the patient requires oxygen supplementation. And this was in fact administered to Ms. Stark days after she required that. And furthermore, the protocol states that later administration with Math Plus protocol can lead to complications such as the requirement for mechanical ventilation. So,
wait, can you repeat what you're saying that the protocol says? The protocol says if you give it late, it will cause complications?
It says that if it's administered later in treatment, that it may cause complications such as the need for mechanical ventilation.
Yeah, I'm familiar with the protocol. I don't know that there's any language that suggests that intent that there's complications. It's less efficacious, like any intervention in any disease. It's presumably would want to give it later. I'm sure it's written to give it as early as possible. But to suggest that giving it later, I don't believe that's within the language of that protocol.
Okay, and no, I obviously trust your opinion on that. However, this was in the document that was provided to Dr. Lutzier at the time, and it stated that there may be complications such as the requirement for mechanical ventilation if administered, not within the first, yeah.
Understood,
so,
fair enough.
But counsel, just to counsel, sorry, but to follow up on my question and your answer, wasn't it the case that her decline in health occurred because the ivermectin was not continued and the math was not continued upon the order of Dr. Lutzier? And you're suggesting that she took the ivermectin, but her health declined in any event. And in fact, according to the evidence we have, it's because it was not continued, or at least temporally connected with the fact that it was not continued, that her health declined again.
Thank you for your question. And we submit that it is possible that Math Plus and ivermectin did improve her condition. However, there also is the possibility that deviating from the standard treatment plan and delayed treatment with Math Plus resulted in these further complications. And we just want to remind the panel that it's the plaintiff's burden to to prove that it's probable that these treatments improved her outcome. And we're saying it's merely possible that it did.
Council, on that point.
My question, actually, before we move on, I just wanted to ask my question. I just wanted to clarify with you if there's a determination that's been made that there's a linear deterioration in one's health condition as they progress through their COVID-19 illness, or whether there's actually a possibility for improvement, perhaps even spontaneously, and then once again, deterioration further to that. Were you able to establish that?
Yes, I was. So thank you for bringing that up. The CDC has warned that some COVID-19 patients will rapidly deteriorate about a week after onset of illness. And we have other sources that indicate that while patients might start to feel better around days 7 to 8 of illness, symptoms can worsen. And that does roughly line up with Ms. Stark's condition.
Council, I just have a question, because I'm a layperson. Is
Yes.
there any evidence in the record? This is all very interesting facts about her clinical course, which maybe I could draw an inference, but is there any expert evidence that would assist me in drawing this inference? So by a physician who's qualified in this area to opine on what the likely course of her condition would have been. Do we have that in the record?
Sorry, could you rephrase the question?
Yeah, is there an opinion from a physician that indicates what her likely course would have been if the treatment had been continued? Is that in the record to assist me as a layperson?
Thank you for that question. There's nothing in the record from an expert to say that if she continued supportive care, she would have more likely survived. Yes, no problem. Barring any further questions, I will continue with my submissions.
On that course of illness that we've described and that my justices asked about, is there any, are you aware of any trajectories of COVID which involve a sort of a bimodal appearance where patients suddenly get better, get worse, get better, and then get worse? Or without specific changes in treatment, is it your understanding that the general course is one of a plateau and slow deterioration? Because I'm not familiar with that improvement, getting worse, improvement, and getting worse. I hadn't heard that described in relation to that disease.
Thank you for your question. Yes, and I think what you describe is generally the course of, somebody will get COVID and they will deteriorate at a, rapid progression. However, the FDA states that there are cases where people will start to get better and then they will rapidly deteriorate. So again, COVID is such a novel virus that—
Hold on. She's already in the deteriorating phase. She's already in a hospital in ICU. So that decline already occurred. I'm talking about in the latter phase where they sort of get better and get worse. Has that been talked about? Is there expert testimony to say that's the usual pattern? And that makes, the idea that they gave him ivermectin. You said, it sounds like your opposition with the opposing counsel is that you think it's possible, they think it's probable. And I think it's important to understand whether that trajectory could have happened without introduction of specific treatments, whether it's the natural course of events. Do you have evidence to show that that would have been the natural course of events if ivermectin had not been introduced?
Yes, so I did, again, the FDA stated that a patient can start to feel better around days 7 to 8, and then they can get worse. So okay. I don't have evidence before me to say you could get better, worse, but that is the evidence I'm relying on.
Understood.
Thank you. Now, as of October 19th, 2021, Health Canada has actually warned health professionals against using ivermectin to treat COVID-19, explaining that Health Canada has not yet received an application for clinical trials for ivermectin for treating COVID. Additionally, in Dr. Strange's deposition, she concedes that the CPSO issued a warning to her to stop administering ivermectin for COVID-19. So the facts say that the regulatory body for physicians and the federal health agencies do not recommend treating COVID with ivermectin or Math Plus due to the lack of evidence. I wish to also pose that Ms. Stark's deterioration might have been due to the virus alone. Again, as I stated, some patients will rapidly deteriorate about a week after onset of illness. And as both sides have accepted, Ms. Stark presented to the hospital with moderate to severe COVID-19 symptoms and then entered the ICU with critical conditions. The plaintiff has presented theories about the efficacy of Math Plus and ivermectin that are not backed by government health agencies, who all recommend treating COVID with remdesivir and recommend against using ivermectin. Unfortunately, Ms. Stark entered the pulmonary phase of COVID-19 during her stay at the hospital and developed advanced lung disease as a result, which is the leading cause of death in COVID-19 patients. The question is whether by withholding ivermectin or Math Plus, Dr. Lussier contributed to her death. However, the evidence and studies before us simply do not point conclusively to this. To conclude my first point, the plaintiff has failed to meet the burden of proving causation, and therefore Dr. Lussier cannot be found liable in medical negligence. Moving to my final point, West Valley Memorial Hospital is not liable for Dr. Lutsier's actions because Dr. Lutsier met the standard of care and did not cause or contribute to Ms. Stark's harm, and thus is not liable in negligence. The hospital may only be found vicariously liable if a salaried physician is negligent in their care of the hospital's patient. There is no liability without negligence. If this court does find that Dr. Lutsier's failing to review the literature is a breach of the standard of care, there are strong policy reasons to not hold the hospital vicariously liable. In Baisley and Curry, the Supreme Court states that vicarious liability is appropriate when there is a significant connection between a risk created by the employer and a resulting wrong committed by the defendant. I wish to point out that Dr. Lutsier's employment agreement, in Dr. Lutsier's employment agreement, the hospital states that a physician shall render services in a competent, professional, and ethical manner in accordance with current and prevailing medical standards. Furthermore, the hospital fosters an environment of ongoing learning by having an interdisciplinary team review the new literature for COVID-19 monthly and amend their treatment protocol on that basis. The hospital did not create a risk that new literature would not be considered. They actually advance the goal through their actions and their employment agreements. This simply does not create a risk for resulting harm that needs to be deterred by the court. And it would also offend the court's conscience to extend liability to the hospital because a doctor decided not to review the literature on one occasion. To conclude my submissions, we respectfully ask that this court not find against Dr. Lutsier for negligence. In times of a global pandemic, the court should not set a precedent that encourages doctors to deviate from the standard of care set out by federal health agencies. This would put patients at a greater risk, and the public would lose confidence in the healthcare system. Doctors should not fear liability and negligence for following the accepted standard of care. Dr. Lutsier did not breach the standard of care, nor did he cause or contribute to Ms. Stark's untimely death. As a result, this court should not find Dr. Lutsier nor the hospital liable for damages owed to the plaintiff, and we seek the award of costs as a result, and such further and other relief as this honorable court deems just. Subject to any further questions, that concludes my submissions.
So your argument is that as long as they follow federal health agencies, are those healthcare organizations? Do they provide medical care, those organizations? The ones that you're citing?
No.
They don't?
No,
Okay.
they don't.
When they put out protocols or guidelines, is it mandatory that the physician follows them?
I would state that it's not necessarily mandatory that they follow them. However, in this case, we have to think about what the reasonable doctor in Dr. Lutsier's shoes would do. And in that case, it's safe to say that a doctor should feel able to rely on what the FDA and Health Canada recommend.
They can certainly do that. They can rely on them if they want. I just want your argument, your final argument, it has to be clear that anything put out by any agency, any society, has always been called a guideline. And a guideline, in every guideline ever published, as I understand that literature, states that it's not a mandate and that the ultimate choice is for an individual patient is up to the patient and provider. Your opposing counsel talked about a failure of collaboration, a failure of interaction, review of new evidence, whether they review it every month or not, as well as a failure to transfer. I don't think you've addressed any of those things. So if they refuse to provide something that a patient advocates, do you want to try to touch on those aspects of the opposing counsel's arguments that this physician and hospital actually failed in a collaboration, keeping up to date with the literature that was provided? That 78 controlled trials was very timely. And also, is there a duty to transfer to help this patient get the best possible care? Because they did not want to offer anything else but than what was provided. But the ultimate choice should be patient and provider. And if that patient chooses something else than the provider, would it be reasonable that they seek out a different provider and be helped to do so?
Thank you for your question. So to speak first to the failure to transfer the patient. So proving causation for failure to transfer a patient relies on the belief that if Ms. Stark had been transferred to Dr. Strange, it is more likely than not that she would have survived. However, as we saw, Ms. Stark presented with moderate to severe COVID-19 symptoms, and by the time they requested transfer, she was critically ill. So we can't say with the evidence before us that it is more likely than not that had she been transferred and administered ivermectin, she would have survived. And sorry. And with respect to collaboration, again, my co-counsel spoke to this, but collaboration is totally appropriate, and especially in a situation where there are multiple approved treatments available, then that would absolutely be necessary. However, in this case, unfortunately, what we're seeing is that remdesivir and dexamethasone are approved by the federal health agencies. And furthermore, the CPSO actually recommends against treating COVID and issued a warning to Dr. Strange as a result. So there weren't multiple options available. There was one standard care that was well researched, and that.
Are you aware of any other instances in history of medicine where an organization or society would reprimand a physician for using a medicine that's used widely around the world in 25% of the Earth's inhabitants for this disease? Or any other instance of a doctor using a medicine using their clinical judgment, expertise, understanding of the literature, and their professional discretion? Has there ever been instances of agencies reprimanding physicians for using something that they have the clinical right to use based on their judgment? Because I find this an odd situation that you're presenting. You're saying that physicians are using regulatory approved, unparalleled safety profile with the opposing counsel mentioned 78 controlled trials with 85,000 patients in total. The point estimates of the summary is benefit. Do you want to speak to why an agency would reprimand a physician who uses a medicine in that case?
All I can say.
Reprimand. Why would they reprimand?
Yes. So all I can say to that is that the CPSO, their position is that there is not enough literature available to prove that ivermectin is effective in treating COVID specifically.
Okay, so not to use. So basically, the point of the CPSO and why you cited them is that you believe it's correct that they reprimand physicians until they deem the evidence is sufficient. So while people die and deteriorate from a disease, while evidence builds up, if someone uses it prematurely for when they say it's okay to use, that's a correct regulatory environment that physicians should be obedient to.
I don't agree that that's necessarily a correct regulatory position that the CPSO is taking. However, again, we have to look at a reasonable doctor in Dr. Lutzier's shoes. And in this case, when he's considering whether it's foreseeable that treating with ivermectin or Math Plus would help or harm the patient, if the CPSO, Health Canada, and FDA are specifically warning against using it, a reasonable doctor in his shoes would find that it's likely not a good course of treatment. I can only look at it from that position and not on a more global scale.
So it seems like your argument might might argue that your argument leads to that the hospital doctor is not liable, but it might be the CPSO that's liable.
And that would
If indeed they
definitely,
were incorrect, and if indeed these actions caused the patient's death, it sounds like maybe the liability lies upstream.
and that would be, something that if the plaintiffs had concerns about that, they could bring that matter before the court in another matter, but that's not a matter that's before us today.
Understood.
Thank you.
Counsel, may I ask you one question?
Yes.
So could I turn this around a little bit? Because I think that what I'm hearing, part of the problem is, we're treating populations versus treating the individual. Many guidelines and trials are done on populations, recommendations on populations, but we have an individual in front of us, and the courts are concentrating on that doctor-patient relationship. And I think the difficulty we're having is understanding what would be reasonable for a practitioner who's using an off-label therapy to determine whether it was providing benefit or not. And I think that's been many questions around that. What if I turned it around the other way, that person was prescribing remdesivir as part of the protocol, and that patient continued to have a side effect, continued to drop their blood pressure, but the physician continued to reapply it in the face of a side effect, which has previously not been described for that drug, and something is happening to that individual, and that individual died. Would that physician be held responsible? Would that physician fall below a standard of care?
Thank you for your question. No, I understand that those would be very different circumstances. And however, I can only speak to the facts that are before us today. It's hard to look at a situation where the facts are different. However, what I do know is that this is the recommended treatment for COVID-19, and COVID-19 is constantly developing. So if the treatment changes, then that might be a question for another time. However, based on the facts in front of us, I can't conclusively speak to whether that physician would fall below the standard of care.
Counsel.
Yes. Subject to any further questions, that concludes my submissions.
Counsel for the plaintiff, will you be using your optional rebuttal? It will be 5 minutes instead of 3.
Yes, thank you. I'll for all of our sakes, I'll try and keep it shorter than that. Thank you, justices, and thank you for the defendants for making those submissions. First, the defendants had submitted essentially that we can infer that Dr. Lutsier had seen the studies that Dr. Strange had provided to him or had reviewed all that research, given the fact that he conducts monthly meetings with his team. We would just like to submit that there is a possibility that that research could have been brand new, given that those 1-month windows do exist. And when we referred to his act of asking for the research from Dr. Strange, we were simply presenting that as indicative of Dr. Lutsier's own acknowledgement that research is always evolving and that possibly there was something new that he hadn't seen. Second, in response to Justice Hibbett's question, the defendant had noted that the doctor had briefly skimmed the literature provided to him by Dr. Strange. We would submit, based on what he said in his cross-examination, that he didn't review the literature at all, or perhaps didn't even have a look at the email, because at paragraph 497 of Dr. Lutsier's cross-examination, he absolutely mischaracterizes what was sent. He states that there were about 5 studies sent to him from low-quality journals, not peer-reviewed or showing any benefits of ivermectin. And yet what he was actually sent was a meta-analysis of Math Plus and ivermectin, plus the FLCCC review. Lastly, we would just like to make a note regarding the comment about Dr. Strange having been asked to step down from her role. There's a lot of internal politics that go on within these boards and within these colleges, and there's a lot of controversy regarding ivermectin currently at the moment. So we would submit that given that Dr. Strange hasn't been sanctioned, she has not been brought to a disciplinary tribunal, and this was a private internal political thing that was asked of her, that this should not be used to discredit her or discredit her testimony. Thank you.
This concludes the matter of Stark v. Lutsier.